is Family Law and Grandparents. My name is Belinda Jeffrey and I'm the presenter. To let you know a little about me, I am an associate with Michael Lynch Family Lawyers and have about 13 years experience in the area of family law. I enjoy undertaking family law matters because I like the challenge of helping people to know what they're dealing with and to assist them in a time when it's arguably one of the most difficult times of their lives. Michael Lynch Family Lawyers is a boutique family law firm, and this means that we advise and act in matters which are only within the family law jurisdiction. The benefit of yourselves or your clients using us is that we have over 25 years of experience. We have 12 lawyers, including accredited specialists, and we know the area of family law so very well because we are that boutique firm. Today's webinar, as I said, is about grandparents and the family law system. So a bit of an overview of what we're covering today is to really get your bearings and give you some terms and who's using, what courts are used so that you can talk to your clients about that. Parenting arrangements and answering some of the questions that I thought grandparents may have. Speaking about child support and how that relates to grandparents, and also property or financial division and how that relates to grandparents. I'm of the view, as I said, it's helpful to gain an understanding of some basics. So getting your bearings is really about understanding the basics. The Family Law Act is the jurisdiction that we're talking about. Under the Family Law Act, we have rules. So we have the family law rules and the Federal Circuit Court rules. That's because there's two courts, the Family Court and the Federal Circuit Court. It was previously known as the Federal Magistrates Court. It has just been announced, and many may have seen it in the media, that there is actually going to be a merger of the courts, and that's anticipated to happen in or about September this year. At this stage, I'm not sure how that will change too much, other than we're not going to have those two separate courts. But that's important to understand as well. The relationships that the Family Law Act deal with are married and de facto relationships. There's both same-sex and heterosexual. Some legal jargon that I think pops up in matters and something people should be aware of is parental responsibility, time arrangements, child support, property financial settlement, mediation, interim hearing, affidavits, subpoenas. So there are court fact sheets available that talk about this legal jargon that can be accessed by people, but it's also important that you familiarise with the use of that language. Understanding who are the personnel in court is also important. So we have in-court judges and registrars, and in the legal system we use barristers and solicitors. So I am a solicitor. A barrister is someone who doesn't work necessarily in a firm. They are a firm within themselves, and they take briefs to act from solicitors. So they do the everyday court work required to argue before judges and registrars. You may have clients who are grandparents, or you're a grandparent yourself, perhaps. As grandparents, they may be caring for or raising their grandchildren, or maybe have been stopped from seeing a grandchild. Some questions that I thought of when I was preparing for this webinar are, do grandparents have rights to see their grandchildren? Can a parent deny a grandparent time? Can grandparents go to mediation? Can the court get involved? I thought these might be questions that you're being asked, or if you are a grandparent yourself, you might be asking. What's important to understand is that the Family Law Act, which applies across Australia, and I say across Australia, although Western Australia has a different Family Law Act, it's very similar to the rest of Australia. It relates to separation and divorce, division of property, and who a child lives or spends time with when parents separate, whether or not their parents were married or in a de facto relationship. So the Family Law Act acknowledges the importance of children having a relationship with grandparents. Grandparents are specifically mentioned in the Family Law Act as being able to apply to a court to have orders in relation to their grandchildren. But it's important to be aware that this doesn't mean that grandparents or indeed parents have an automatic right to have contact with the children. So best interests are paramount, and there's two issues that the court will always need to decide when it comes to children. That's parental responsibility and living arrangements. Some background about children, and again, I've put these slides in because I appreciate that there's different language being used, and some people who have gone through the family law system, and I'm talking more about a grandparent who may have gone through the family law system, would be aware of different language than what is currently used in court. So as you'll see, and as the slide says, prior to 1996, we use words like guardianship, custody, and access. Post 1996, the language that the court used was residence, contact, and specific issues. From the 1st of July 2006, we were using words like lives with and spends time with. So we got rid of the language of guardianship or custody or residence or contact, but rather we created neutral language that talks about a parent that lives with and a parent that spends time with. Or in this situation, we'd be saying that the child spends time with a grandparent, and that might be the maternal, paternal, grandmother or granddad. Some other concepts to understand is parental responsibility. So parental responsibility can take different forms. Parental responsibility can be in relation to day-to-day issues, but more often when we talk about parental responsibility, it's about the major long-term issues for a child. So the Act says that parents of a child have equal shared parental responsibility. That's the presumption under the Family Law Act. That means that parents of that child must inform, consult and agree about the major long-term issues for that child. But the day-to-day issues that fall for the child, so things like what do they eat that day? Do they wear the yellow shorts or the blue shorts? Can they have an ice cream? Those day-to-day issues fall to the person who's looking after them on that day. Why I make mention of this is that sometimes when we're seeking arrangements in relation to children, we're not necessarily seeking arrangements about parental responsibility. And for grandparents particularly, it may be that they're not seeking to have a say in those major long-term issues for the child, but rather they're just wanting to have arrangements for the child to spend time with them or communicate with them. So it needs to consider, if court action is required, what it is that you're actually asking the court to do. Parental responsibility is one of those areas that the court will want to understand what's being asked of them. My next slide is about shared parenting and just really a parenting overview. It's not so much in relation to grandparents, but in relation to parents and what the court considers. When the presumption about shared parental responsibility is upheld, the court has a requirement under the legislation to consider an equal time arrangement for a child or a shared care arrangement. And failing that being reasonably practicable or in a child's best interest, then any significant and substantial time. You'll see there that I've put the exception of family violence about shared parental responsibility. So often a reason why the presumption about shared parental responsibility is rebutted is because there's been a high level of family violence that would make it more difficult for parents to inform, consult and agree on those major long-term issues. So this slide doesn't really relate so much to grandparents, but it gives an overview for grandparents to understand about the larger dispute that may be happening between parents and where they fit into that dispute and what they could necessarily agitate for. I wish to talk about the best interests, and you'll recall that I said that it's about the children's best interests. That's what will be the paramount principle that the court will have regard to. In that, there are primary considerations and additional considerations. So the Family Law Act makes it clear that the best interest of the child is the main consideration when it comes to decisions about parenting. The focus of the Family Law Act is on the rights of the child to know and be cared for by both parents and other people significant to their care, welfare and development. So this is grandparents and other relatives. The court can decide what orders to make based on what is in the best interest of a child. Parenting orders can deal with where the child lives, who they spend time with, who has parental responsibility, what communication the child is to have with other people, including telephone, FaceTime, or email, and any other aspect of the child's care, welfare, and development. The court will primarily look at that benefit, but also the need to protect the child from harm. The court will also look at and consider the views of the child, and the importance given to the child's views will depend on their age, maturity, and level of understanding, the child's relationship with parents and others, including grandparents and other relatives, each parent's willingness and ability to facilitate and encourage a close and continuing relationship between the child and other parent, the effect of any change to the current situation on the child, practical difficulties and expense involved in spending time. So as you can see, these extra additional considerations really make up all the different uniquenesses that children in different family situations have. So it's about what other considerations will be relevant to determine what's in a child's best interest. Most separating parents will try to reach agreement about who the children will live with, but it's not always the case that the parents have to be separated for a grandparent to agitate that they spend time with a child or a grandchild. So if parents are in an intact relationship, but they are refusing for a grandparent to spend time with a grandchild, the grandparent can still commence court proceedings in those regards, or seek to have some sort of dispute resolution to discuss what time the grandchildren should spend or communicate with them. If you reach agreement, you can formalise that informally, so without any documents and without going to court. These decisions can also be put into a written agreement, and that's called a parenting plan. It sets out arrangements for the child. Parents will sign that agreement, and any other third parties, so the grandparent, should also sign that agreement. It shows an intention only, so it's not legally binding or enforceable. The other alternative is to put the agreement into what we term a consent order. So a consent order is a document that's lodged with the court, it's in writing, signed by all concerned parties, and it's submitted for approval by the court. It becomes legally binding and enforceable. That means that if one person subject to that order isn't following it, there can be consequences for their failure to follow it. You would go to that level if you had concerns that a parent wouldn't follow it, or if you wanted absolute certainty that you could rely upon that agreement. The difficulty, though, with a written agreement in a consent order form is that it doesn't have the level of flexibility that could be afforded in an informal arrangement or a parenting plan. So it does set out in very black and white terms what time a child would spend with a grandparent or what time a child would communicate with a grandparent. And unless the others agreed to vary that on a once-off occasion or on a more longer-term occasion, then it would be as per that agreement, whether it suited the child or the grandparent. That's how it would need to be. And the only way to change that would be by taking the matter to court. Those orders are in place until a child turns 18 years of age. If going to court is really a next step, and one that should be carefully considered, because if a grandparent is being denied time and they've attempted the mediation, well then really they need to decide whether they do go to that next step of doing court proceedings. What I would urge the grandparent to do is, if they haven't had legal advice at that point, to go off and speak to a legal advisor and get some advice about what they should have in terms of expectations, but also think about mediation and whether they try and approach mediation in a different way to maybe what they've done. Dispute resolution is something that receives government funding. So grandparents are eligible to access the government-funded dispute resolution process. That's Relationships Australia, Uniting Care, Family Relationships Centre. So the dispute resolution process doesn't always have to be face-to-face. It could occur in a shuttle format, or it could occur via phone or Zoom, and especially now with the COVID-19 pandemic, a lot of platforms have been created so that these types of dispute resolution can occur. It could also be the case that a grandparent could engage a solicitor to have some discussions with the other parties about getting access or communication, and talking about what are the parameters to that, or why they're not agreeing, and trying to work through those processes. Another idea that might be worthwhile for a grandparent is to think about using a family counselling service. So a family counselling service is where it's a confidential process. It's not dispute resolution, but instead they're using yourselves as counsellors to assist them in a family therapy and environment. That would be done without the privy of the court, but could assist to maybe work on an issue. And it may then be a first step before going to a dispute resolution. So they could attempt the dispute resolution after there's been some family counselling, if that was an issue that was identified. The dispute resolution certificate will be required if a matter is to be taken to court. So you should always get legal advice before taking legal action, including about how strong the case is. You wouldn't want to go down the path of court if you hadn't already had some legal advice about it. If the case goes to court, there will be a hearing, and a court will decide what is in the best interest of the child, taking into account those factors that I earlier mentioned. The court can require parties to contribute to try and resolve the dispute themselves. So within the court process, they may engage in other activities in order to reach an agreement and to be able to foster some sort of agreement that could be reached. In some cases, the court can order that an independent children's lawyer, or an ICL as they're sometimes referred to, be appointed to represent the children's interests. That lawyer's role is to form an independent view of what is in the child's best interests and make the court aware of those interests. The court can also order a family consultant, so again, having that counselling involvement, to interview and observe the children and prepare what we call a family report for the court's benefit. It's important that people are aware that court is not a quick process, and it can take more than 12 months from the date of applying for final orders to be made. There are, though, opportunities for orders to be made on an interim basis or at certain points as the matter proceeds through the court pathway. So I touched upon the court process. What it involves is filing of an initiating application. And in that initiating application, it's going to set out what, as a grandparent, you are seeking. So it will set out whether you are seeking parental responsibility, and perhaps you would be if you are raising that child and you have been raising that child. So I'm thinking of a scenario where the child has been left with a grandparent or grandparents because the parents haven't been able to care for the child for whatever reason, and now the parents are now agitating for the child to be returned to them. That might be a case where a grandparent seeks some parental responsibility. But on most occasions, grandparenting applications will only seek for the grandchild to spend time with them and communicate with them. The first court mention, you will have the benefit of understanding what the parent's position is to the application. As I said, the application can be brought against parents who are in an intact relationship or parents who are also separated. Both parents must be a part of that application, though. It's not the case that you would only bring the application against one parent. I touched upon earlier the family report and the independent children's lawyer, and it could be the case that an interim hearing is run before a final hearing. It will really turn on the facts of each case. What would make a court make interim orders about a grandchild spending or communicating with a grandparent is if there are no risk factors that the court needs to be aware of. And in the past, the grandchild and grandparent have enjoyed a meaningful and loving relationship. So it's important in any material that you file with the court, and that's the affidavit that a person would file, you set out what your relationship has been. You talk about what phone calls you have, what occasions you've celebrated together, the things you enjoy doing together. So that may be teaching them how to knit, how to go fishing. If you have a love of car racing and they've come to the motor racing with you, putting that into your material about those occasions where you've spent meaningful time together and where you have that meaningful relationship, and setting out exactly what it is that you're seeking. My tips in relation to parenting and agitating for arrangements about grandchildren is that a grandparent should get some counselling. They should try to understand and educate themselves about what are maybe some of the issues that the parent, especially if parents are in an intact relationship, why they're saying a grandparent shouldn't be involved in that child's life. It's important to get legal advice before agreeing or implementing any plans so that you understand and what it involves. Consider mediation or consider dispute resolution. Beware of putting things on social media. Consider a communication book. So if you are needing to keep a record of time that you've spent in anticipation, you might need to bring such an application. A communication book is a way that you can record that, and keeping a diary of significant child matters. My biggest tip is that people should get legal advice. And of course, I'm going to say that, I'm a lawyer, but I think it's very important in these cases. If you don't understand what your rights are, if you don't understand what the case is that's being made out, you're going to come unstuck. So it's important to get advice early on from someone in that area of law who can give you some tips, even if it's just, have you thought about that? Have you considered this? Or given you other avenues to probably proceed in a non-litigious way if you don't want to go through a lawyer themselves. This is probably the transition now into today's webinar topic, where I talk about financial issues. So in particular, child support. There are several Commonwealth payments that are available to assist grandparents raising and caring for children. And some of them are not always known to grandparents. As long as you have the legal responsibility and day-to-day care for your grandchildren, you may be eligible for financial assistance. You must have at least 35% of actual care of the child to be eligible for family assistance, and generally will not be eligible for family assistance if the parent of the child also lives in the same household. Some other Commonwealth assistance payments that you might be eligible for that may not be known are Family Tax Benefit A, Family Tax Benefit B, the childcare benefit, the carer allowance, so if the grandchild has a disability, youth allowance, so depending on the age of the grandchild and the level of care that you're having, healthcare cards, and also Medicare cards. These are important other Commonwealth payments that you might want to look into. As I mentioned, if you provide care for your grandchild and you have at least 35% of the time, you'll be able to receive some support. You'd make that application with the Department of Human Services Child Support, or Services Australia as they're also known. It's an income tested benefit. So it will look at the income of all parties who have care of the child or who are parents of the child, and then they will do a calculation of the amount of care you have to work out what you would be liable to either pay or receive. And it may depend on what that level of care and what that income is. But it is something that should be looked into, especially if as a grandparent they are having that greater than 35% of time. Another element where I thought grandparents might have an interest, and not so much in terms of time with grandchildren, but where they've given financial support. So they've given financial support to their child, or they've given non-financial support in terms of caring for the grandchildren. and their child is now going through a separation, and they're talking about the property and financial settlement between them. So we often advise clients about those financial and non-financial contributions that they've made as a grandparent. And some of the ones that we're seeing more typically now is, as I refer to it, as the bank of mum and dad. So to get into the property market, they're either offering assistance through debt consolidation, or they're offering assistance to get into and buy a property. So they're putting up the deposit. They are otherwise doing a guarantor of a mortgage or a loan. They're funding private school fees for a grandchild or grandchildren, or they're doing that care of grandchildren in lieu of daycare or during school holiday periods, so that parents aren't having to then fork out money for those things. I thought it was important to touch upon how these feature in family law matters, and in particular property and financial settlement. So one of the things relevant to this is keeping documents. Having documents that set out what the expectations are. And that's difficult when we're dealing with personal relationships and we're wanting to give children some assistance. And I say children, I'm meeting the adult child, but we also need to protect our interests. So it's not in our nature sometimes to think about a loan agreement or registering some sort of mortgage over a property, or thinking about entering into some sort of written agreement about repayment of any monies that have been loaned. But it's really something that should be at the forefront of your mind. You should get some advice about what risks there are. If those parties do separate, who's going to meet that debt? What's the expectation of when that debt is met? Will there be interest paid on that debt? These are the sorts of things that should be set out in an agreement. Ideally, a loan agreement or some sort of other contractual agreement, but at very least in writing somewhere that is signed by all parties, so that in the event it needs to be enforced or there needs to be any sort of proceedings about repayment of that debt, where the grandparent needs to intervene in a property and financial settlement to make sure that they do get repaid monies, there's evidence of what those monies were and what the expectations were. And often we hear the argument, well, I didn't know he or she did that with their parents. Having it set out, having it known is going to be the easiest way of agitating that it should be enforced to be repaid. School fees are a little bit different. Again, if you are doing that as a gift for the benefit of your grandchildren, perhaps you don't have an expectation that that's going to be repaid. But in terms of a property and financial settlement, it might be something that one party says, it should be a contribution weighted in my favour because my parents or my parent put up the monies for our children. So keeping, again, documents about what you've paid, when you've paid it, when you were asked, who asked, they're important documents. Similarly, the non-financial contribution about daycare and during holiday periods, your best record of that is going to be through some sort of private diary or note keeping, and where you acknowledge that you're going to care for those children. That is a contribution, a non-financial contribution, that an adult child could agitate during the property and financial settlement that has saved them considerable funds, because we all know daycare and school holiday care is quite expensive. So my emphasis here is about documents and evidence, and it needs to be done at the very start. You need to set up a system about how you're going to reach the agreement, what you're going to do in relation to that agreement, and everyone needs to be on the same page. Transparency about that agreement and what the contributions are need to occur. I thought at this point I'd open it up to some questions, because I appreciate that there are probably questions out there that I haven't answered, and I wanted to give you that opportunity to ask those questions. No questions? If you think of questions beyond today, I'm happy to take emails, and you can email us at our email address, which is going to be on the next slide. If you have a client or you yourself need some advice as a grandparent, reach out to us. We offer a fixed fee initial appointment, and we can usually schedule those appointments fairly quickly. We have a number of lawyers, as I said, so we have availability to schedule those appointments Monday to Friday. We can do them by Zoom, we can do telephone, and we can also have face-to-face appointments. I hope today's been helpful, and I hope you've enjoyed our webinar. Thank you.